Well, the attorney for General Flynn, Sidney Powell, well, she just destroyed Barack Obama's ass. I mean, she just lit him up on fire in public and left him there to burn for everybody to watch. This is an open letter, an open memorandum that she penned and published today, and I'll just start right in at the beginning here. This is regarding your failure to find precedent for Flynn dismissal. Regarding the decision of the Department of Justice to dismiss with prejudice the information filed against General Flynn with the concern you expressed in your phone call with alumni, quote, that there is no precedent that anyone can find for anyone who has been charged with perjury just getting off scot-free. That's the kind of stuff where you begin to get worried that basic, not just institutional norms, but our basic understanding of rule of law is at risk, unquote. Apparently you need more help than you realize, as your statement is entirely false. However, it does explain the damage to the rule of law you allowed throughout your administration. First, General Flynn was not charged with perjury, which requires a material false statement made under oath with intent to deceive. 1. A perjury prosecution would have been appropriate, and the rule of law applied if the Justice Department prosecuted your former FBI Deputy Director, Andrew McCabe, for his multiple lies under oath in a leak investigation. McCabe lied repeatedly under oath in fully recorded and transcribed interviews with the Inspector General for the DOJ. He was fully informed of the purpose of the interview, and he had the benefit of counsel. And he knew he was in trouble. McCabe even lied about lying. And to his own agents, which took their investigation on a, quote, wild goose chase, unquote, because McCabe was himself the source of the leak they were investigating. Attorney General Barr declined to prosecute McCabe for these offenses. Under the rule of law, after declining McCabe's perjury prosecution, there are no other circumstances pursuant to which DOJ could continue to prosecute General Flynn, who was not warned, not under oath, had no counsel, and whose statements were not only not recorded, but falsified by the agents. Second, it would seem your wingman, Eric Holder, is missing a step these days at Covington and Burling, LLP. Indelibly marked in his memory, and one might think yours, should be his motion to dismiss the miscount of the multi-count jury verdict of guilty in the entire case against the former United States Senator Ted Stevens. Within weeks of Mr. Holder becoming the AG, he had to move to dismiss the Stevens prosecution in the interest of justice for the same reasons that the Justice Department did against General Flynn. Egregious government misconduct by the prosecutors who had hid evidence and made up purported crimes. As horrifying as the facts of the Stevens case were, they pale in comparison to the targeted setup, framing, and prosecution of the newly elected president's National Security Advisor, General Flynn, and the shocking facts that surround it. This case was an assault on the heart of liberty, our cherished system of government, of self-government, and the right of citizens to choose their president. The inability, third, of anybody in your alumni association to find anyone who has been charged with, or anyone charged with anything, just getting off scot-free, would be laughable if it were not so pathetic. Many of your alumni were featured prominently in the non-fictional legal thriller published in 2014, Licensed to Lie, exposing the corruption in the Department of Justice. A national bestseller, it focuses on the egregious misconduct of your longest-serving White House counsel, Catherine Rumler, your counterterrorism advisor, Lisa Monaco, Loretta Lynch's DAG for the Criminal Division, Leslie Caldwell, and Mueller protege, Andrew Weissman. While they worked as federal prosecutors on the Enron task force under the purported supervision of Christopher Wray, they destroyed Arthur Andersen LLP and its 85,000 jobs, sent 4 Merrill Lynch executives to prison on an indictment that criminalized an innocent business transaction, and hid evidence that showed they were innocent for 6 years. Both cases were reversed on appeal for over-criminalization and misconduct. Indeed, Andersen was reversed by a unanimous Supreme Court. Fourth, even your many alumni don't remember the multiple reversals and cases that had to be reversed or dismissed by their own misconduct, and we're guessing Judge Emmett Sullivan will remember tossing out Stevens. Judge Sullivan is the judicial hero of License to Lie. And it was that case of the resulting 500-page report of Henry Schulke that caused the Judge Sullivan to enter the strong Brady order the Mueller prosecutors violated repeatedly in the Flynn prosecution. The fifth, your alumni Weissman and Rumler are no strangers to guilty pleas being tossed. At least 2 guilty pleas they coerced by threats against defendants in Houston had to be thrown out. Again, for reasons like those here. The defendants, quote, got off scot-free, unquote, because like General Flynn, your alumni had concocted the charges and terrorized them into pleading guilty to offenses that were not crimes. Anderson's partner, David Duncan, even testified for the government against Anderson in its trial, but the plea had to be vacated. Enron broadband defendant Christopher Culker had his plea thrown out also. Sixth, should further edification be necessary, see Why Innocent People Plead Guilty, written by federal judge Jed Rakoff, a Clinton appointment. In 2014, innocent people are forced to plead guilty by abusive prosecutors with painful frequency. The Mueller Special Counsel operation, led by Andrew Weissman and the Weissman wannabes, specialized in prosecutorial terrorist tactics, repulsive to everything justice is supposed to mean, and designed to intimidate their targets into pleading guilty and punishing them with the process and financial ruin. So it's not that they're guilty, it's just simply that they're ruining them with the process. Most important, though, in truth, General Flynn was honest with the FBI agents. They knew he was, and briefed that to McCabe and to others at 3 different times. McCabe's directions, Agent Strzok and McCabe's special counsel, Lisa Page, altered the 302 to create statements that Weissman, Mueller, Van Grack, Zainab Ahmad could assert were false. Only the FBI agents lied, and they falsified those documents. Those crimes are theirs alone. Now, seventh, the federal circuit in which you reside threw out a Section 1001 case for a legal failure much less egregious than those in General Flynn's case, United States versus Safavian, 528, and there's a bunch of jargon here from 2008. Safavian sought advice. Safavian sought advice from his agency's ethics board and didn't give them all the relevant info. The jury convicted him on the theory that a 1001 violation to conceal the info from the government ethics board. The court disagreed. Quote, as Safavian argues, and as the government agrees, there must be legal duty to disclose in order for there to be concealment of an offense violation of Statute 1001A. Or really, just more simply put, you have to tell them if you're asking for them to give you something, otherwise they can't knowingly conceal it from you. Pretty simple. General Flynn did not know that he was the subject of an investigation, and in truth, he wasn't. The only crimes here were by your alumni in the FBI, the White House, the intelligence community, and the DOJ. These examples are obvious and well known, and perhaps you will soon find some remarkably good jailhouse lawyers to consult for further assistance on your research for precedent. Finally, your leaked comments on the call with your alumni further evinces your extraordinary obsession with destroying a distinguished veteran of the United States Army who has defended this country from all enemies, foreign and domestic, and with the highest honor for 33 years. Now, there's a footnote here from Sidney Powell. As a constitutional lawyer, surely you recall the perjury or false statements were also require intent to deceive, and she gives an explanation of how General Flynn knew and remarked the transcripts in his conversations that he did not believe his answers were ever false, and that others knew they didn't believe his answers to be false. We'll see what Barack Obama says to this. Holy smokes. I mean, can you imagine getting this posted to you about you? Barack, you got some splaining to do.